Hello, everyone. We are live on our first session of this conference, Emerging Areas in African Disputes. I would like to thank Agnes Gitau. I would also like to thank all the keynote speakers who joined us. I'm sure you will all agree that we all benefited from hearing about the work that is being done at the ALSF.
Yes, Mr. Ivan.
So I would like now to introduce the moderator of our first panel, Mr. Evans Monari, who is partner at Bowman's Kenya, Coulson Honey LLC. Mr. Monari is a disputes lawyer, has a long career in disputes. He has led some of the leading cases in Kenya, including acting for the government of Kenya in international arbitration matters, including ICSID arbitrations. He is highly regarded on all legal rankings, including Chambers Global and Legal 500. He is leading a very leading panel of arbitration practitioners and commercial lawyers in discussing the emerging areas in African disputes. With those comments, I now welcome you, Mr. Monari, to introduce your panel. Thank you.
Thanks, Wairimo. Very flattering remarks indeed. But wait until you see who you have on this panel. The theme for this afternoon in our first discussion is actually fourfold. We are going to look at trends in African energy and natural resources, the disputes around that area. We'll be looking at the development in Africa's Islamic investments. We'll look at financial trends in BITs. We'll also touch on investment arbitration in Africa. Now, with us, we've got four very formidable speakers. Let me introduce them. The first one is Juliet Mazera. Juliet Mazera is an advocate at MMC Asafo, Kenya. She's very experienced in development and financing of PPPs, and she's quite well known in that area. She has advised on a $60 million road project. She's working on the Kenyatta National Hospital, which is our largest referral hospital in East and Central Africa, where she's advising the hospital on its development projects. She has experience in Islamic financial transactions. She's an expert on Sharia compliant banking and is rated highly by the IFLR. And we in Kenya see her as a rising star in her field. And she can claim that as her field. We also have Mr. Osama Ombada. Mr. Osama Ombada is a Sudanese lawyer. He works at Azatan, is a Sudanese law firm, which is very well known. Osama is in charge of oil, gas, and mining, and the mining section at Azatan. And he's also a member of the special assignments team within the firm. Mr. Osama is an expert in acquisition, project funding, construction, agriculture, and telecommunications. He is very fluent in Arabic and English, and he manages the firm's legal and contractual aspects and claims before courts, administrative tribunals, and arbitral panels. We then have Mr. James Keruki. James Keruki is here. He's the chairman of the Young Arbitrators, the newest chairman, I think. He's an associate at IKM, DL Piper, Kenya. He has advised on multi-million arbitration, and he has been involved with others in his firm in actually winning that arbitration on behalf of the government of Kenya. He is a known mediator and adjudicator, and he has done his Master of Laws in International Investment and Trade Law. We also have, last but not least, Judy Reindorf. Judy Reindorf, associate with Hogan Hovels in Dubai. She advises on very high-level arbitration in the Middle East involving iconic projects in the Middle East. She is experienced in top-end work and in complex disputes. especially commercial disputes, where she deals with multi-million-dollar shareholder disputes, and particularly the interaction between Islamic and secular law in contract interpretation. You will agree with me that we have a team that is going to give us some insights on the thematic area that we are discussing this afternoon. Straight away, I think then we should start with just a few words by Juliet Mazera, and then we'll move on to Osama, and then we will go to the rest. So Juliet, it is your time now.
Thank you, Evans. You can hear me?
Yes.
Awesome. So thank you so much for that wonderful introduction. I'm very excited to be a part of this event. So I'm going to be taking us through developments in PPPs in East Africa. So basically, we are seeing more and more governments opting for PPPs as opposed to traditional procurement when it comes to infrastructure development. And maybe I should start by just quickly describing what a PPP is. So a PPP in full is basically a public-private partnership. It's a long-term contract between a public party, which would be a government or a government entity, and a private party. And by long-term here, we are looking at periods in excess of 15 years. So PPPs are usually used for the development and management of a public asset or the management of a public service. And when it comes to the development of a public asset, we are looking at things like the construction of a road, the construction of a bridge, a port, or a power plant. When it comes to risk in PPPs, more often than not, you'll find that the private party bears a significant risk throughout the life of the project or the life of the contract. But this should not deter private parties whatsoever, because you'll find that generally risks in PPPs are usually allocated to the party that is best placed to bear that risk. Maybe one thing that makes PPPs different from traditional procurement methods is that private party bears significant management responsibility throughout the life of the contract. And the private party, you'll find that also provides a significant portion of the finance, and this is always done at the private party's own risk. And then, unlike traditional procurement, in PPPs, you'll find that remuneration is significantly linked to the performance of that asset or that service that's being provided by the private party. And then also remuneration, you'll see that could also be linked to the demand or use of that asset or service. So just how are we doing in East Africa? How are we faring in terms of PPPs? When it comes to the legal and regulatory framework, having a dedicated PPP law kind of provides some semblance of predictability. An investor always knows from the get-go how PPPs are governed, how are they procured, and it offers some sort of guidance or guidelines as to what to expect. So they're not really groping in the dark. They have like a guideline that they can follow and know what to expect. So in East Africa, we're seeing that most East African countries have dedicated PPP laws. So between 2010 and 2016, we had the opportunity of seeing Kenya, Uganda, Tanzania, and Rwanda all enacting laws that were dedicated to PPPs. In terms of total investment in active PPPs, in Kenya, we're seeing Kenya is leading at $3.4 billion. And then we have Uganda at $1.6 billion that are invested in active PPPs. Tanzania, they're at $824 million, and then Rwanda is at $655 million. The largest PPP projects in East Africa, interestingly enough, happen to be in the energy sector. And we're seeing the likes of the Lake Turkana wind farm in Kenya. There's Bujagali hydro project in Uganda. There's Songo Songo gas to power project in Tanzania. And then there's the HQ power plant in Rwanda. So the largest ones are being seen to be mostly in the energy sector. But so we're doing quite well there. In terms of the other sectors, we're seeing quite a number of roads in Kenya that are being procured as PPPs. And under the Road and Unity program, I know the government had a very ambitious plan to have 10,000 kilometers worth of roads being constructed under that program. And I believe 2 so far have already reached financial close and are being constructed. Rwanda, in terms of other sectors that they're doing well in PPPs, they have the Kigali bulk water supply project that's under the water and sewage sector. Tanzania, they have the direct submarine broadband cable that is in the ICT sector. So there are quite a number, and it's not just in the energy sector. There are quite a number that are coming up in different sectors, and also, and those ones which I've mentioned are the ones which have actually reached financial close and are in the actually in either being constructed or in operation. So there are quite a number also of projects that are still in the PPP pipeline and are either going through the feasibility studies or are at the procurement stage. For example, recently we had one that had been advertised for the transactional advisor for the Nakuru in Kenya, for the Nakuru Solid Waste PPP. So there's quite a number that are in the pipeline. So luckily for us, there's so much that is coming in the near future that is going to be quite interesting for people in the either in the legal sector or the engineering sector or any other sector for that matter. So with that, Evans, maybe I can hand it back to you in case you have any questions.
Yeah, we will be coming back to you, and I'll be asking you on how easy it is to get letters of comfort from the East African governments, and probably can give us an insight to that. Now let's move over to Osama. Osama, if you can just make your short presentation, and I know that you had already told me that you speak very fast, and your time now. Osama, yeah.
Okay, thank you. I just want to thank you for everybody. I'm very thankful for this opportunity, speaking to you all. In fact, my line here is not that good. I hope you hear me. If you have any problem, you can just see stop me. Just say stop. Send me a signal. I'm going to give this talk regarding the Trans-African Energy and Natural Resources disputes. I'm going to just in experience with regard to this natural resources disputes. Sudan was not known as a petroleum country, but I just want to give you a background. This exploration of petroleum started as early as 1959 by Agib, the Italian company. That was offshore operation. They didn't make anything. Then Chevron in mid-70s, the American oil company, they did manage to have some discoveries like but they the area because of political issue. The 90s, a concern of Chinese CPC of China, Petronas of Malaysia, State Petroleum of Canada. This is replaced by Talisman and Sudapet, the national oil company of Sudan. They were just took over what known Block 1, 2, and 4 in Sudan, and what was operated by Greater Petroleum. That the oil was 99, September 1st, 1999, and the production goes up to 180,000. During that first the construction of pipeline, we have had a big dispute between the consortium and Teshent, that is Argentinian company, with regard to claims. The real claim in the range of 30 to $31 million, but they have, did some legal engineering and claimed like 600 million. They claim that they are partner in the early scheme called Early Production Program, so they accelerate the production and they have to share with the partners the revenues. And that dispute was under ICC rules. London as a forum, and these laws were governing the dispute. That dispute was settled to 30 million, and most of the the claims were change orders, accidents, and normal types of claims under any construction contract. And what is very strange on this arbitration, this arbitration has involved like 70 or 80 people of different disciplines, engineers, of different lawyers, everything. The only African involved in this are two local Sudanese lawyers are giving their being used as experts. The other people, all of them of European or American origin, we have it like in 18 months or less, we have 8 or 9 million as fees, and nothing goes or went to African lawyers or whatever. This is one. This is my first example of this big dispute, which involves a lot of it. Africa has to do that. The resource is African, the dispute is in Africa, but no African lawyers or experts of whatever discipline were involved in that. Then we have the other case. The other case is this is between Sudapet Petroleum Company, this National Petroleum Company, again is the government of South Sudan. This case because of this of the country, the newborn country took all the assets of Sudapet. Sudapet is a government-owned company, and Sudapet has applied for this dispute. They submit their claim to the international exit. You know that International Center for Settlement of Investment Dispute, exit in Washington. Again, all the involved for South Sudan and South Sudan were represented. Like 80% of them are of European and American origin. Only few people from Sudan and South Sudan, and that is another issue we need to look into and see how we can catch up as African lawyers or arbitration centers to catch. Another case, now it is in the pipeline. This is a dispute between ONGC, this is the Indian Oil and Gas Corporation.
Mr. Sama, you're breaking off.
Sorry?
You're breaking off a bit. If you turn off your camera, perhaps we'll hear you better.
Okay. Now, do you see me? Now, are you following me?
Yeah, I'm saying if you can mute your camera, if you turn it off, perhaps.
Yes, my camera is on.
Yeah, put it off. So we see whether you have. But anyway, continue. Let's see how far we do this.
How can I put it off? I don't know how to put it off.
And just go on, Mr. Sam.
Okay, so the other dispute, which pipeline, is between the government of Sudan and ONGC, this is Oil and Gas Corporation of India, and this is because of the entitlement of the petroleum, which being taken by the government, and they didn't pay the money to them. Again, this is in the pipeline, and I don't know whether if any of our African centers or arbitrators could catch that. But the bottom of what I'm saying now, for us in Sudan, all the dispute relating to this natural resources or the oil disputes being arbitrated by non-African arbitration is in London or Washington, then to see how we can fill these gaps and catch up. That is my, so we need to make a recommendation that African arbitration centers shall make more effort in introduce their centers and promote African lawyers to work as professional arbitrators. And this cannot be done unless doing that at very early stages when the governments getting in contracts, they have to take that in consideration. So we need a big shift here from London to Nairobi, to Addis Ababa, Khartoum, or taking you or any other African lawyers as arbitrators. That is my statement. If you have any question, I'm ready.
Thank you very much, Mr. Sama. Very interesting insights as to what is happening in Sudan. And we'll come back to you when I'll be asking you about the future of the oil industry given the independence of Southern Sudan now. I will also touch on the Ethiopian dam with you when we come back to you. Right now, let's go to Judy Rendo, and she's going to let us have her piece, and then we will move on from there. Judy Rendo. Judy, I think we can't hear you.
Hi, can you hear me now?
Yeah, that's slightly better.
Hello?
It could be, yes.
Okay, apologies. Thank you very much, Evans, and to my fellow panel members as well. Very excited to be here. By way of my opening remarks, as it were, I will be speaking about Islamic finance and as well what the lay of the land with respect to dispute resolution is in the area. I will touch on two main points to kick off the discussion, and I'm anticipating there will probably be some questions from the panel later. The first question, obviously, and is a good place to start, is what is Islamic finance? Essentially, what it means is providing financial and investment products in a manner that is compliant with Islamic law or the Sharia. We see some principles of Sharia law which set apart Islamic financing from conventional financing that you and I may be more accustomed to seeing. I'll just quickly list a few of these principles, but it's by no means an exhaustive list. The most common one that may often be heard of is the prohibition of interest or any unjustified increase of capital, which is known as riba. The prohibition of gambling or excessive uncertainty in finance documents, the principle of profit and loss sharing, and also the principle of excluding and financing sinful or haram activities. So where conventional financing, for example, may have a loan that bears interest, or perhaps you'll have future or forward options, those types of typical conventional arrangements would not be permissible under Islamic law, and therefore Islamic finance finds creative ways or alternative ways of financing transactions with those principles I have just listed in mind. With the increasing popularity of Islamic finance across the world and Sharia compliant investments, what we're seeing as international lawyers is at Hogan Lovells is an increase in queries from not only clients from Islamic countries or with Islamic principles in their business, but also from secular entities as well, where there may be some kind of Sharia angle in their transaction, which they would like advice on. And to me, this is demonstrating that across the world, with Africa being no exception, there is a growing demand and interest in Islamic finance as a method for financing corporate transactions. Before I continue, I think it's important to observe that Sharia law isn't a codified system of law with statutes and legislation as we may be used to in our home countries. And it's not tied to any particular jurisdiction. So essentially what that means is that there will be governing principles and ideologies which will overarch a transaction and which a transaction must be held in compliance with. But in terms of whether or not there's a codified system of Sharia law, I would have to say that there isn't necessarily one. What we are seeing is that most Islamic finance documents, at least that come across my desk, are governed by English law or the law of another secular jurisdiction, but then impose elements of Sharia compliant principles. This can create some challenges when it comes to dispute resolution further down the line, but I will touch on that a little bit more now. So Islamic finance dispute resolution, and how does this differ to dispute resolution in more conventional financing areas or other corporate matters? I thought it'd be interesting just to observe before I go into any further detail that obviously Islamic law and Islamic principles came from the Arabian Peninsula and have since been spread across the world, with obviously many countries across the world outside of the Gulf being Islamic countries. However, dispute resolution in an amicable context is very deeply entrenched in Arabic culture. I am British, but when I'm working with my Middle Eastern clients that end up in this dispute, one of the first questions they ask us is, how can we settle this? And not, as you may see with other clients from other parts of the world, let's go to court and have our day in court. With an Islamic finance context, the Quran does provide a duty to reconcile disputes in an amicable way. And so under Islamic culture, conciliation, mediation, and arbitration have historically always been seen as the more preferable methods for resolving disputes. So for one example, the principle or the method of al-sul or settlement is a legally binding contract which binds the disputing parties and also the wider community to uphold the agreed settlement terms. So there's a little bit of historical flavor, but in the present day, what does dispute resolution mean? In modern Islamic finance context, we see a lot of preference. We see general preference for arbitration over litigation, although litigation is still very widely used. We have seen in the Middle East and also parts of Asia the establishment of specific Islamic finance arbitration centers. So, for example, in Dubai, there was the International Islamic Center for Reconciliation and Mediation, which was inaugurated in 2005. While obviously the option is there in Islamic finance documents to refer arbitrations to these centers under such rules, the general consensus seems to be that the uptake for such Islamic finance-centric arbitration rules is still quite low, and parties are generally opting for your typical LCIA, ICC rules with seats in London, Paris, New York, the typical usual offenders. However, with dispute resolution in mind, and my previous comments about arbitration being seen as more favourable, I do think that secular arbitration can still work, as long as the parties in question recognise that they need to exercise their discretion in making sure that the arbitrators they appoint have the requisite Sharia knowledge and background to appreciate the nuances of some of the arguments that do seem to come up time and again in Islamic finance disputes. So I think with that bearing time in mind, I will conclude my introductory remarks there, and I'm very happy to take any further questions.
Thank you very much, Judy. Let me quickly just move to James Keruki. James, let us know how the world of BITs is going and where we are with the investment arbitrations. James.
Thank you so much, Evans, and thank you so much for the organizers and this fantastic panel thus far. Am I audible, just for certainty's sake?
You're good.
Thank you very much. So I'm going to approach this topic by more or less two main questions, which I believe sums up where this conversation is going to go. And the first one or rather the first question is, where have we actually come from? And more or less, what's new with respect to BITs and investment arbitration? And that means where are we right now? And so with regard to where we've come from, I think it's important to appreciate the context from, or rather the development of BITs and investment arbitration in specific, and note that, well, BITs is just one form of international investment agreements, and generally international investment agreements commenced in more or less 1959. And at this time, we all know that Africa was under colonial occupation. Majority of the countries at this time were either trying to leave or were still incumbent within that situation. So while the wave of independence was spreading during the 1960s, it was very clear that these economies were ailing and they needed to open their markets. So what they did in now efforts to do this was they more or less accepted the ICSID Convention. And as Mr. Karigizi put out in his introductory statement later on, there wasn't really much sight into detail when they were doing this. So another aspect which we need to appreciate is that investment arbitration, and in particular BITs, is more or less very African in the sense that the first arbitration, or rather the first investment arbitration involved, or rather was against an African state, in this case, Morocco. This would be seen in the Holiday Inns essay and others versus Morocco. This is a 1972 matter. And also the first award by an ICSID tribunal was, or rather had a party which was an African state, Cote d'Ivoire. And so it's clear that Africa is well involved in the development of investment arbitration and BITs. And well, of course, to add, the first BIT between African countries was between Egypt and Somalia, and this was in 1982. So it was also very clear that at this time, or around this period, a majority of the countries signed and ratified the New York Convention, which now introduced the important aspect of enforcement within this sector. So, of course, as a consequence of all of this, there was an increase in GDP and GDP growth and output growth with respect to African countries. And as of March 2019, there are a total of more or less 350, or rather 531 international investment agreements by African states in force, and 517 of these are BITs. So it's very clear that BITs are very popular. So another interesting fact would be that in 2018, 11 of the 56 cases requested in ICSID were against African states, and half of these related to oil and gas. So we are very involved in this sector. And as a result, as now time progressed, people started to see incumbent and inherent issues, particularly with respect to ICSID at the time, which was the most popular vehicle for this investment arbitration. And there were some issues with respect to inconsistency with treaty interpretation. There was lack of transparency, double hatting, which would lead to conflict of interest issues, the fact that only investors could bring about claims, and private arbitrators more or less determining and discussing matters of public interest. And you could understand why there would be a divergence in actual connection between those two actions. So another one, or rather now in the form of this context, is one of the issues that was very, very apparent and has been pointed out by the speakers before me, is that there was, or rather still is, very poor representation of African arbitrators. So it's been made very clear that there is no shortage of qualified international arbitrators within this continent. And as a matter of fact, the Chartered Institute of Arbitrators did a survey in 2017 where they established that out of 15,000 arbitrators in their record, 2,483 were Africans. And well, of course, with Nigeria holding the majority and Kenya and other growing countries following suit. And also, and it's good Amelia is with us because according to the Arbitration in Africa survey, the previous one, not the current one, it was made very clear that 41.1% of African experts who are arbitrators in at least one domestic dispute, and 17.8% were arbitrators in a foreign dispute. So it's clear that the internationalization of this space is still yet to see a lot of African involvement. So in essence, one of the other issues, or rather one of the main things that we became more cognizant over time, was that it became clear that our agreements are beginning to, or rather are more or less outdated. Over 200 BITs were signed between, or rather in each of the years of 1994, 1995, and 1996. And these are many BITs for one period. And so the 90s saw a surge in popularity when it came to BITs. And what the United Nations Conference on Trade and Development, UNCTAD, did was that they started issuing out reform packages where countries could pick along these things and gradually update and review their BITs. And according to UNCTAD, in their report in 2018, over 120 BITs were revised as a result of this. However, there's still an inherent issue with regard to the plurality of investment agreements, and in particular BITs. There are very many, and it is very clear that some international investment agreements, which cover regional areas, do not address the intra-African BITs, and thus there will be contradictions left, right, and center. So the other limb of more or less this conversation would be what exactly has changed. And so in this regard, we can now talk about, following from the criticism that revolved around this area, what started coming up, or what we call, or rather what is termed as the new generation BITs. So in what new generation basically implies, or what it tries to put in, is that as a result of the skepticism towards investment arbitration, and in particular with respect to African states, African states more or less started, or rather they stopped being really forthcoming with BITs, and they've actually seen a drastic reduction in the ratification of new BITs. Because in the last 25 years, only 25 BITs have been entered to, and within African states, or pertaining to African states. And what they intend to do is now strike a balance between the interest of the state and the interest of the investor, with key aspects such as sustainable development and aspects such as no compromising in dealing with certain aspects of state sovereignty like health and environmental standards. So one key BIT which has managed to do this, despite the fact that it's not in force, is the Morocco-Nigeria BIT, which actually, or rather, sorry, before I move into the merits, there's also the definition of what actually constitutes investments. This is another issue, because where there are catch-all definitions and where it's not specified, claims can be brought from left, right, center, and they will not be limited to certain aspects. So what this BIT has actually tried to put forward is it has tried to define what assets fall under investment and what assets don't. This is in Article 1 of the same. And it also imposes obligations upon investors, not just the state having obligations against investors themselves. And also clear provisions on sustainable development, environmental standards, and also the fact that investments must meet international standards of practice. Now, moving on to more radical developments, and in particular with the southern area of Africa. And I'm going to deal with the Protocol on Finance and Investment by the South African Development Community and the 2012 South African Development Community Model BIT. So these are more or less, they have recommendations for the member states. And one of the most controversial developments or movements would be the fact that international, or rather investment arbitration, should now be disregarded, and we should move towards a system where we exhaust local mechanisms local remedies, or rather using local facilities within that host state. So, of course, this has raised a plethora of criticism, especially with respect to investors. And some of the recommendations from especially the SADC model BIT is that sometimes they recommend not to use investor state. There's some recommendations not to include exceed arbitration or omission of the most favorable nation clause, recommendations to remove the fair, equitable standard, and a number of other things. What other developments have also taken place within the same region is that they're now beginning to omit investor state dispute settlement mechanisms and also investor arbitration to promote more or less the local systems. And South Africa has done this through local legislation, through the promotion of the Protection Investment Act 2015. And as a result of this, they terminated 14 of their 47 BITs. And this was motivated by a number of things. For example, the attribution of privileges to private investors that extend beyond that of domestic law, freedom of arbitral panels to interpret provisions of BITs, which what I mentioned was the expansive interpretation. For example, the fair treatment, the host state would now be so careful not to upset the investor expectations, even those that are within the course of reasonable expectations, such as environmental measures, measures to now adopt the new wave of sustainable development, even tax. So others have opted out of investor state dispute settlement and investment arbitration, such as the Ethiopia-Brazil BIT, although it's not in force, but it's one of the ways that we're going. Also, other people are trying to establish standing tribunals. These tribunals are established at the inception of the International Investment Agreement. And in the case of, say, a BIT, and I'm going to make reference to the Singapore EU document, Singapore EU Investment Protection Agreement, which parties, or rather the state within the EU and the state in Singapore, have to appoint 2 panelists from each country and then jointly appoint 2 others at the inception of the agreement. And what this will do, if replicated here, will now promote, say, diversity issues, because we are going to now have to opt to appoint the people the state would prefer. African arbitrators for African arbitrations, and this will be key in this development, and also party involvement, more party involvement, and time and cost savings. So in essence, now I've already addressed exhaustion of local mechanisms, but there are also 2 others, which is now adopting alternative dispute resolution methods, and also such as mediation, negotiation, and also traditional systems, which are very cognizant within the African continent. And you can say without a doubt that we still hold them to a high regard, and the same regard is not held in more or less the international scope. So what then now, or where would you say that we're headed? And this is me concluding. So in essence, we are headed towards Africanization of investment arbitration. In Mr. Karangizi's introductory remarks, he mentioned a few institutions, and he also, well, I don't need to move through them because there are quite a number of national institutions, regional bodies that want to actually promote, that can actually host international investment arbitrations and can actually manage disputes that arise from intra-African and African, when an African state is a state to an international investment agreement. So in essence, what all of these things boil down to, and what was hinted by Mr. Karangizi in the beginning, was that we are now moving towards recognition of our own systems, our own institutions, our own people, and this boils down to the Africa Continental Free Trade Area discussions, which have been a culmination of over 6 years of talks by AU states, and this will promote a market of over 1 billion people with a combined GDP of 3.4 trillion. These are astronomical numbers and quite intimidating on the global scale, and it is only upon joint collaboration and actual realization that we have the capacity to move into the international investment and BITs and generally international investment agreements space as Africans within our own capacity, then we can actually now change the space and introduce more or less a system that will be self-governing by our own people and our own systems. I think I'll stop it at that, and I'll leave any questions to be asked with respect to what I've discussed in the plenary session? Thank you very much, Evans and the panel, for this discussion.
Thank you, James. You've done very well. Let's go back to Juliet. Juliet, what are the opportunities that are available in the PPs sector with regard to arbitrations? Is there a possibility that arbitrations can take place where you have PPPs? And also, remember the question about how easy is it to get letters of comfort from African governments?
Okay, so maybe I can start with the first one, being how easy is it to get letters of comfort. So letters of comfort could also be letters of support, and perhaps I can speak to a sector which I've had the opportunity to work in, which would be the road annuity program, where the government, as I said earlier, was very ambitious in terms of constructing 10,000 kilometers of road in Kenya. So the government of Kenya at that time, through the National Treasury, had opted to give letters of support. And the letters of support is basically intended to insulate a private investor from certain elements of country and political risk. So in the case of the road annuity program, the government issued those letters of support, but they were very restricted. They weren't covering just all events of default. They were specific to those that were arising as a result of political risk. But there have been developments since then, because I think the time when the first road reached financial close was in 2017. In 2018, the government of Kenya actually did publish policy on its issuance of government support measures. So these would be letters of support, letters of comfort, just in the hopes of providing more clarity as to what instances the government was willing to give these letters of support. So we're seeing more and more letters of support or comfort being given in the energy sector and also in roads. And then maybe I can go to your next question, Evans, which is what opportunities are there for arbitrators or arbitration in PPPs? Maybe what I can say is that you'll find that most international investors would be quite uncomfortable with the idea of having their contracts subject to local judicial proceedings. And why is this? Because a country's judiciary may not be seen as sufficiently independent from the government for it to make a private party comfortable that just redress will be available for it. And what governments have done, and this is Kenya, Uganda, Rwanda, have set up PPP laws which actually do provide for alternative dispute resolution mechanisms. There's the PPP Act for Kenya, the PPP Act for Uganda and Rwanda, allow for arbitration or any other non-judicial means for dispute resolution. In Tanzania, however, there's been recent developments which are pushing for local arbitration and not international arbitration. And Tanzania has argued that international arbitration is inherently biased in favor of investors, and that method of dispute resolution prejudices the interest of Tanzania. So you'll agree with me that the fact that this alternative means of dispute resolution, it being enshrined in law, actually then opens up opportunities for arbitrators in the PPP world. Yeah.
Thank you very much. So, Mbada, if I may just start the questions I hinted. What is the future of the oil industry in this region, given that Southern Sudan got its independence a while back? And is there some form of stability there that we can expect that there will be improvements?
Okay, thank you. In fact, the problem that faced Sudan upon the independence of South Sudan, the most rich fields were just went with South Sudan. So what left for Sudan, the production, it was in the range of 400,000 per day, remain to be in the field producing in Sudan like 150 to 180, now only 60,000 per day, the production. Even in South Sudan, production declined sharply because of the civil war there. However, in both countries, there is a very, very big opportunity of oil. For Sudan, we have more than 15 blocks, which should be tendered for investment. I think they are just waiting the political situation to to stabilize in Sudan, because now we are passing through this transition period of government after Bashir, and I think they at least they have 15 blocks to be tendered. The oil industry in Sudan facing very high cut of water. The investors already left Sudan, the big investors, CNBC and Petronas, because of the USA sanction imposed in Sudan and the differences and dispute over their money, which or oil taken by the government and money not paid to them. For South Sudan, I think if they manage to settle their civil war, it is very rich country. They have a lot of areas of exploration, and this is, I think, for the African lawyers and African investors, they have to be in the first row when these tenders are offered, because it's a very big opportunity to them, and maybe they need through the government, or they have to approach at least the government of Sudan, trying to introduce themselves. So the choice will be to African arbitration centers or arbitrators to be selected as arbitrators by agreement.
Related to that, Mr. Osama, as a direct question, is the Sudanese government now opening itself up and warming to other African lawyers outside of Sudan to either be arbitrators in matters involving Sudan and or prosecute and or defend the government of Sudan?
Yes, I think it's a matter of communication. For example, now the African Legal Support Facility Unit is doing something for Ministry of Energy, trying to develop their petroleum agreements. And I think that the African support, legal support facility can have some influence over the government, at least to propose, because the government of Sudan, like others, as Juliet just said, everybody thinks that Africans are not qualified enough to be arbitrators. Arbitration in Khartoum or in Nairobi will be seen as biased to the local people. So we need to sell ourselves that we can be international and we can do it just like London, Paris, or any other place.
Thank you. Just to go back to Judy. Judy, what is the place of arbitration in Islamic banking and investment transactions?
Thank you, Evans. As I previously touched on earlier, arbitration is seen, at least culturally, in a lot of Islamic cultures, amicable settlement and arbitration is seen as the more favorable way by which parties can resolve their disputes. I think especially where you have finance documents which are containing governing law clauses, as is typical, you'll have a governing law clause, which is the law of a particular country. And then you also have the imposition of Sharia law principles. That internal conflict is not easily resolved by litigation. And so parties often opt for arbitration.
Thank you.
Each party can make sure that there's a requisite expertise for actually resolving the dispute in a way that is compliant with issues of Sharia. Sorry, can you hear me?
Yes, we can hear you. Yes.
Okay. So the role of arbitration is a potentially quite great one. I think there are a couple of areas on the African continent as well, where Islamic finance is particularly a growing area for attention, and where the need for Islamic finance expertise on the continent is becoming even more palpable. Typically, as you may know, Islamic finance and banking services generally provided in GCC countries, and also a lot in Southeast Asia, Southern Asian countries such as Malaysia. However, Africa is a growing center for demand for Islamic finance and Islamic finance dispute resolution as a result. One such area is, and I'm glad to have colleagues on this panel who have spoken about infrastructure projects. Financing for infrastructure projects has been historically quite challenging to meet that gap in financing, and the prevailing view in the Islamic finance world is that Islamic finance can help to bridge that that gap. So international arbitration necessarily becomes involved when you look at the picture from a macroeconomic perspective of what the role of Islamic finance can be. Typically, financing infrastructure will come from conventional banks through conventional financings. However, when you think about it, around 53% of all Africans are Muslim. And so relying so excessively on financing projects from the commercial spheres may necessarily exclude institutions and individuals alike if they want to make sure that all of their dealings are Sharia compliant. Having Islamic finance on the continent will also open up the continent to investment from other jurisdictions and also encourage further investment from the Gulf regions, many of which, if they are Islamically financed, will be looking to make sure that principles of Sharia law remain in place and complied with for the duration of their transactions. So from that perspective, we cannot separate not only the arbitration angle, but also the Islamic finance angle from the overall development conversation when it comes to infrastructure projects, access to banking for individuals and also institutions alike. I understand as well that there are growing regulatory measures being put in place across the continent with countries such as South Africa, Nigeria, Kenya, for example, making sure that their regulatory mechanisms do not penalize Islamic finance projects just for the way that they're structured, and actively encourage foreign investors who would prefer to do so via means of Islamic financing have those facilities available on the continent. And I think this is something that has begun in the last decade or so in Africa, but there's definitely a way to go when you consider that I think only about 16 African countries have Islamic finance institutions in their financial makeup at all. So with all of this considered, arbitration will continue to be the core area for dispute resolution in Islamic finance, and especially so as the demand continues to grow for such finance products on the African continent.
Thank you very much. There's a specific question asked by the audience, and this is from Nakili Fitzwanga, and it's directed at James. James, you've seen the question? And the question...
I can see 3-4 questions addressed to me. I can't... by whom again?
If you have seen the 3, just say the question and answer very quickly. Please don't take more than 3 minutes.
All right. Thank you very much, Evans. So the first question is by Edgar. I've seen the question by Samrawit. So I'm going to combine because I think they're all related. So in your opinion, how may the Africa Continental Free Trade Agreement Investment Protocol accommodate dispute settlement in a way that is fair to both host and state investors? Well, now, first of all, I'm going to combine this answer with Ibrahim Godoffer's question on how can you tie in your discussion with investor-state dispute settlement in Africa, and what do you think that the upcoming Africa Continental Investment Protocol portends in this area as well? So first of all, we need to acknowledge that many African countries are already in pre-existing agreements, and these will not just disappear by virtue of a new joint continental agreement. So what the Africa Continental Free Trade Investment Protocol, trade agreement, would have to, first of all, in my opinion, deal with the plurality of agreements across the continent, because many of these were entered into at a point where we didn't have leverage with respect to the certain provisions. And only then, when we have addressed all of this, because they're still binding and those that are still in force, and we cannot ignore this, only then can we now move on to a debate as to how to make investor-state dispute settlements. And of course, now tying it into Samrawit's question, how to make it fair to both state and investors. So in respect, or rather in this aspect, so I already mentioned in my presentation that there are some certain clauses that need to be addressed, such that, for example, if you now bring about the national treatment, for example. So what exactly is national treatment? And it has to be put to the investor that it is treatment no less than what the local investor would be put, or rather what a local investor would be subject to. And so what is fair and equitable treatment of an investor? It shouldn't be broad to the extent that countries are literally in fear to change their regulations such that a single change may now be the subject of a claim. So there's supposed to be, or rather, creation of exemptions in certain areas, particularly dealing with policy that affects public interest of states. And when I say public interest, I now mean interests that affect the populace. Even, for example, you can now talk about environmental issues, health issues, sustainable development in general, which again is a global movement. Africa is no exception. So in this case, with respect to these agreements, what would constitute fair and equitable treatment would be treatment within the bounds of the investment, but should not trickle down to things that would now affect, so to speak, the populace in a negative way, and what would lead to now what people, or rather within the investment space, is called regulatory chill, where countries will not change or will be hesitant to make a drastic, or not even a drastic amendment, an amendment that would be within the line of, say, normal discussion. And once they do that, they will be subject to a claim. And of course, I've mentioned the costs associated with claims. They can literally bring down a country in terms of its economy. So within that space, the way the Africa Free Continental Trade Agreement can actually move in to make it fair to both state and investors is to impose more, or rather more obligations, actually, yes, more to investors, because inherently the current agreements were drafted with the mentality of protecting the investor. We need to now move it back to the center by creating these provisions where we can actually get FDI, foreign direct investment, because it is clear that it's a benefit to an economy. We are not trying to say we don't want foreign direct investment, and make it such that it will not be to the detriment of the citizenry and, to the larger extent, the state. There's only one. Oh, sorry, you can cut me. I think I covered all questions. Yeah, that's it.
Thank you so much. In fact, some of these issues will emerge in other sessions that we'll be having in the next day, today and tomorrow. So these answers will come out. I mean, like I've got questions. Since we are dealing with the Africa Free Trade Area, why is Kenya then negotiating a direct pact with the USA? That is for another session, and I wish we could all have met as we normally meet and discuss these issues. I think I need to bring this session to a close. I see Wairimu is with us. Over to you, Wairimu.
Thank you. Thank you very much, Mr. Monari, and thank you to all the speakers. I happen to be the Grim Reaper in the session, which is to say thank you so much to Mr. Monari and your panel, Juliet Mazera, Jody Reindorf, Osama Ombada, James Ngotho. I'm sure everyone will agree that we have had a very interesting session. We are now going to be moving forward to the next session, which is the breakout sessions. The breakout sessions are going to be 2 breakouts. So on your left-hand side of your computer, please select which breakout session you want to join. The breakout session is going to start at 4 p.m. So please do not join from the live session, join from breakout sessions, and you will have 2 choices. We have the breakout speakers ready to go. We are starting off at 4 p.m. Everyone, thank you very much. Thank you to your panel, Mr. Monari, and I am now stopping the broadcast. Asanteni sana. Thank you.